matter of Project Angel Bidco Limited and Access Managing Agency Limited.
Yes, Mr. Sarzide.
My lords, I appear for the appellants with my learned friend Ms. Box.
Yes.
The respondents are represented by Mr. Quiney, King's Counsel, and Ms. McColgan.
Yes.
The first thing I need to deal with is to ask whether your lordships are aware of the application we made for a confidentiality order under CPR 31.22.
Yes.
Whether you're prepared to make
This is in relation to the confidential bundle.
Yes.
Yes, we are prepared to make that. I don't think it's going to be necessary to refer to any of the contents of that bundle.
No, I certainly don't propose to, my lord.
Yeah.
So far the respondents have
Yeah, but you still need the order.
Yes, so my lord, I'm grateful. As you know, this is my appeal on preliminary issues of interpretation.
Indeed.
Arising from a bias-side
I can tell you that we've obviously read the
You've read the
judge's
package, my lords.
judgment, we've
I'm
read the
grateful.
skeleton arguments, we've read the policy, and we have read the marked up passages in the authorities which you have provided.
And indeed, your lordships each have in fact been party to at least one of the authorities, so I know that my lords are well versed in it. We say, my lords, that the order granting permission at Bundle A, tab 12, page 115, hit the nail on the head, that it is indeed surprising if the exclusion in this case has the effect for which the insurers contend. As you know from the skeleton arguments, the appeal has three grounds, and my learned friends have pointed out, and I accept, that ground one is fundamental. Ground one is that the judge should have recognised a contradiction in the policy between the cover granted and the exclusion that's in issue. And if he had recognised that contradiction, then it should have been resolved, which could and should have been done either by the corrective interpretation we urge under ground two, or by the disapplication of the exclusion as we argue under ground three. So I accept that ground one is fundamental to the appeal. As you know, contractual interpretation is a matter of law. This court is in as good a position as the judge to form a view. In this case, there was a dispute about whether there should be evidence. There was no oral evidence because I chose not to cross-examine on it. There was a dispute as to what factual matrix material might be relevant. The judge held that the material the insurers wanted to rely on was not relevant or admissible, and they have not appealed from that order. What I propose to do, unless your lordships ask me to do otherwise, is to start by taking you through the policy in the way that I say it would be read by a reasonable insured, and then make submissions on each ground in turn, including looking at the judgment and what my learned friends have to say on each of the three grounds, and then make a very brief submission about the respondent's notice point. So the policy is in supplemental bundle B at tab 2, page 190, and the basic information in the usual way is on the insurance schedule. It names the insured, item 4, a limit of liability 5 million, retention of 100,000, premium of 80,000 plus IPT, and on the next page, broker commission, 20% of the premium is payable by the underwriters to the brokers. And the schedule lists the various appendices, including Appendix C, the cover spreadsheet, and also Appendix F, the acquisition agreement itself, is annexed. On page 192, we see that clause 1 is the definition section, and I'll come to relevant definitions as they arise, but I should perhaps draw your attention at this stage on page 198 to clause 1.2, the interpretation section. Headings do not affect interpretation, singular and plural, and that kind of thing is in 1.2.
Sorry,
Page one.
what you said to us was that you were going to take us through the policy in the order in which you say it should be read. So is that what you're doing now?
I've taken a very slight alteration from that course by pointing out where the definition section is. As you know, my submission is that you don't start by reading each definition.
Well, I follow that argument. So the order, I think you say, is that the reader goes to the insuring clause first. Is that right? You start.
Substantively first.
Yeah.
But my lord, I'm at the moment. What I'm doing is not very different. Actually, I'm going to the insuring clause next. But a reasonable reader would look at the schedule, see the main provisions. They then see there was a long definition section which they wouldn't read when they were first reading the policy, and they would then go to the insuring clause at 3.1. So, my lord, page 200, and the main purpose of the policy, I submit, is to provide the cover defined by the insuring clause. And what is insured, subject to the terms and conditions of the policy, is any loss covered by this policy with a capital L. Loss, we would then have to go back to the definition section to find the definition of loss, and that's at page 195, and it just takes us straight back to clause 4.1 on page 200. So we then read the definition of loss, and for present purposes, the important part is the first part. Subject to the other provisions of clause 4, loss means the amount of monies which the insured is legally or contractually entitled to claim against the sellers pursuant to the acquisition agreement for a breach, or would be entitled to claim in respect of such breach if the limitation provisions were disregarded. And then there's the addition of defence costs, mitigation costs, and so on. And those are significant in terms of understanding some points in the judgment that I'll come to.
Put shortly, the loss in 4.1.1 is the difference in value between the shares as warranted and their real value.
Yes, because that's the measure of loss for a breach of warranty. So that's usually the amount that would be claimable. Yes.
Yes. So that is something which is independent of any particular loss or liability of the target company itself.
Yes. Exactly so, my lord. Yes. We then, of course, in reading this, need to see the definition of breach. So again, we go back to the definition section at page 192, and we find that breach means breach of certain clauses of the acquisition agreement, general warranties, fundamental warranties, tax warranties, and then the important line at the end of the definition of breach, in each case in respect of any of the insured obligations, capital I and capital O. So, and I just pause to note then that when you get this far, you can see that the peril that this insurance covers, using this sort of insurance language, the peril is the breach of an insured obligation. That's the event which triggers the insurance. So we then need to see what is an insured obligation, and that definition is on page 195. So it's either an insured signing obligation or an insured completion obligation, and in either case, if we look at insured signing obligations, it's the general warranties and other warranties on the commencement date, in each case, to the extent referred to in the cover spreadsheet as covered or partially covered. So there is a clear and binary criterion for what counts as an insured obligation. It's whether the particular warranty or covenant is referred to in the cover spreadsheet as covered or partially covered or not. So a reasonable person at this stage has gone to the insuring clause, gone through the definitions, and will then refer to the cover spreadsheet to find out what are the insured obligations. Which of the warranties, you can see that there are general warranties covered, are the insured ones and which are not. Now, my learned friends, as you know from the skeletons, seek to paint the cover spreadsheet as somehow a subordinate document, somehow not part of the policy. My submission is that's completely wrong. It is an integral part of the insuring clause. You cannot understand what peril is covered by this policy without looking at the cover spreadsheet, which we find at page 213. Although it's called Appendix C cover spreadsheet, and I'm going to keep calling it that, you'll see it's not a spreadsheet in any technical sense. It may have been created on a spreadsheet program, but it is a table. It's simply a table. The rubric of the cover spreadsheet says that this cover spreadsheet contains a conclusive list of the insured obligations, being, and then it sets out the different classes of warranty and the tax covenant. And then there's the last paragraph of this rubric on which, as you know, much of the argument goes into, notwithstanding that a particular insured obligation is marked as covered or partially covered, certain loss arising from a breach of such insured obligation may be excluded from cover pursuant to clause 5 of the policy, and I'll come back to that shortly. The table then traverses the warranties one by one, sub-warranty by sub-warranty, and states for each whether it's covered or excluded. On this first page, 213, we can see a number that are covered, and then when you get to the sort of Schedule 5 main warranties, under accounts and management accounts, we can see most of those ones on that page are covered, but 3 of them are marked as excluded. And just to show you on the next page, you can see an example of a partially covered warranty, warranty 1.5F, which is partially covered because it's deemed amended by the addition of the wording so far as sellers are aware.
Yeah.
That is the sort of usual way in which these kind of policies seem to work.
Can I just ask you this? That
Yes.
what you have been showing us so far is that you go to a clause in the insurance policy, it points you to another clause, so you go and look at that clause, and then you come back to the insurance policy and sort of follow through the trail of definitions. So when you get to Appendix C, why do you not look at what's excluded before you start looking at the table? Because that comes before the table. So you might think, well, I'm being told I'm not to look at the table till I've had a look at clause 5.
Well, my lord, no, because conceptually, what you're looking first, the question is what's covered.
Yeah.
As you're about to work out what's covered, you are warned that even though something may be marked as covered, certain loss arising from the breach of that obligation may be excluded. So you know that if you discover the obligation you're interested in is covered, you will have to look at clause 5. Right. But that's the conceptual order, and that is how any insurance policy works, in my respectful submission, because conceptually, the first question is what is covered, what perils are covered, you know, is this a property insurance, what does it cover? And then one may need to look at exclusions. And indeed all the other terms and conditions. All the terms and conditions may be relevant, but conceptually one starts with what's the cover. The whole purpose of an insurance policy is to cover something. And in this case, the peril is a breach of the insured obligations. That's the peril. That's what my clients may lose out from, is if a breach of the insured obligations occurs. So to find out, first you have to identify what they are. And this schedule, as your lordships know, goes on at the same level of detail for quite a lot of pages.
Yes.
And the relevant warranty, which I say is contradicted on one reading of the exclusion, is at page 224.
Yeah, we're concerned with warranty 13.5.
13.5, exactly. And I draw attention to the fact that there are 8 sub-warranties, each marked individually as covered. And your lordships may want to just quickly look at warranty 13.5 just to see what it is. I'm not this is diversion from reading the policy in the relevant order, but your lordships may just want to know what it is. So that's in the same bundle at tab 1 is the acquisition agreement, and it's page 74. Your lordships can see that warranty 13.5 it is a detailed warranty. Each of the sub-paragraphs has got quite a bit in it. I'm not suggesting we need to read it in great detail, but you can see that A is that the company and its officers, etc., have not committed an offence under the Bribery Act. B, the company has procedures in line with the guidance set out by the Secretary of State under the Bribery Act. C, nobody has paid a bribe, etc. And for my purposes, that's the level of detail I need, but I thought your lordships would want to just see.
Well, we've also got, for instance, D.
Yeah.
It isn't about whether there has been any actual non-compliance. It's about whether there's an investigation going on.
Yes, exactly, into an alleged offence.
Yeah.
An offence or alleged offence, yes.
The E is maintaining a record of hospitality and gifts.
Yes, and F, complying with money laundering anti-terrorism laws. G, not aware of any violation of domestic or foreign anti-bribery laws or regulations, and age remains eligible to be awarded contracts and business under certain sections. So, as I say, that's a diversion, but I thought your lordships would want to just see where it was. Returning to the policy at page 224, the detail then just goes on to page 230, just in the same form of the table. So it follows that, looking back at page 200, we can expand the insuring clause. I'm not proposing to expand it in full, but just expand it so far as relevant for my purposes by inserting some of the definitions. And it will read, subject to the terms and conditions of the policy, the underwriters shall indemnify the insured for the amount of monies which the insured is entitled to claim against the sellers for breach of the acquisition agreement in respect of warranties 13.5a, 13.5b, 13.5c. And that is all part of the insuring clause by simply expanding the definitions. Now, of course, the terms of the policy include the exclusions of clause 5, and those are referred to in the rubric to the cover spreadsheet. And just going back to that rubric at page 213, in my submission, this is an accurate statement of the way that one normally expects exclusions in an insurance policy to work. Certain loss arising from the breach of such insured obligation may be excluded. So what the rubric is doing is it directs attention to each insured obligation separately, such insured obligation, and in relation to each one, it warns that certain loss that arises from the breach of that insured obligation may be excluded. Now, on the skeletons, the parties disagree about what this sentence means as a matter of ordinary English. My learned friends say that it means that for any insured obligation, some or all of the loss may be excluded, whereas we say it means in ordinary English that some but not all of the loss from that that particular insured obligation may be excluded. Loss here has a capital L, so it's the term defined at clause 4.1. And we therefore know that the term certain loss becomes certain of the amount of the monies which the insured, etc. Now, if we just go back to page 200 to see that definition, we can see that it doesn't quite work precisely literally, because you have to make some adjustment to make sense of it, because if you were to read the rubric, certain loss arising from a breach, and then you were to put that insert into that the definition of 4.1.1, you would read certain the amount of monies which the insured is legally or contractually entitled to claim, and that's not good English. The adjustment is obvious. It's certain of the amount of monies which the insured is legally or contractually entitled to claim for the breach of a particular insured obligation. So what that exercise shows is that the sense in which we understand certain loss is certain of the loss, meaning some but not all of the loss. Otherwise you can't read it grammatically. Now, on this issue, it is important to recall that the interpretation of a contract is how it is read by a reasonable business person, not how it is read in one of the authorities by a pedantic lawyer, or in the case of this particular little dispute, you might say by a setter of logic puzzles. And I'll try and explain that, if your lordships will forgive an analogy. The proverbial curate, who was so anxious not to offend the bishop when he was given a bad egg that he said it was good in parts. Now, he might equally have said certain parts of the egg were good. The word certain isn't in the original cartoon joke, but it doesn't change the sense of it. Why is that humorous? The humour arises because when the curate says certain parts of the egg are good, our minds as competent English speakers realise he is saying that some parts of the egg are bad. And we then realise, because we know about eggs, that an egg that has bad parts is a bad egg and cannot have good parts. And we then laugh at the curate's efforts to be delicate and not to offend his bishop. Now, a pedant or a professor of logic would say there's no joke here, no joke at all. Because even if the egg is good, certain parts are are still good. So there's no contradiction, there is no joke, there's no humour. But ordinary English speakers do understand the humour because we infer that when the curate says certain parts of the egg are good, they are implying that other parts are bad. And that is ordinary English in this kind of context. That's the sense in which this is used. If you ask me, and it doesn't depend on my insertion of the word part into that particular joke. If you ask me, do I own the books of Charles Dickens? I might say, well, I own certain books by Charles Dickens. The implication is clear, I don't own them all. So in the same way, that's what the rubric is about. A reasonable business person reads this as saying, okay, some of these are marked as covered, some are excluded. The ones that are covered, even then, some of the loss that could arise from a covered obligation may be excluded by exclusion 5. And that is the ordinary English reading of the rubric. It also makes sense, of course, of the fact that if the intention had been to exclude the whole of a particular obligation, it would have been marked as excluded, which is a pretty important point for the ordinary reader on trying to understand which perils are covered and which are not covered. It's also consistent with the way in which insurance exclusions generally work. They generally do one of two things. They may exclude certain types of loss, like, let's say, consequential loss, loss of profits, things of that sort. So the loss may arise from an insured peril, may be proximately caused by an insured peril, and nothing else, but nevertheless, it's a type of loss which is excluded. That's one thing they sometimes do. Another thing that they sometimes do is they may exclude a loss which is caused by a covered peril, but also proximately caused by an excluded peril. And that's a fairly common type of exclusion. So you might have a cover for property damage that covers fire, is a covered peril, and you might have an exclusion for war damage. So war damage is then an excluded peril. And if the loss is caused by both, then the exclusion dominates. So you could have that, but it doesn't exclude all loss that may be caused by fire. It only excludes loss when there are the two proximate causes. And what exclusions do not generally do is they do not generally simply negate one of the perils that are covered, because that's a contradiction. That is two contradictory clauses. And with that introduction, I turn to clause 5 on page 201. And you can see the exclusions in this policy. There's a set of exclusions first at 5.1 for known issues. Underwriters should not be liable to pay that portion of any loss to the extent it arises out of a breach which a transaction team member had actual knowledge, or if it's been disclosed in the formal process during the acquisition. So that cuts out certain types of loss. It could cut across any of the insured obligations. But what it does not do is it does not contradict any particular insured obligation. There is no particular cover for breaches of which the transaction team had actual knowledge. And then if we go to page 202, we see clause 5.2, which is the list of specific other exclusions. And each of these is done by a particular definition going back to the definition section, and there are 16. So these are cutting out losses that may have concurrent causes, an insured loss and an excluded, an insured cause and an excluded cause. That's essentially what they are doing. And there's no suggestion that in the other 15, other than number 15, that they correspond to any particular insured obligation. That's not anything that's been suggested.
So how do they tie in with the cover sheet, these other exclusions?
Well, the answer is they don't tie in with it, they cut across it.
Right.
So
I mean, take, for instance, forecast.
Yes.
Lapidation liability. Where is that reflected in the warranties?
It's not, my lord, and that's my point. These are normally exclusions are not reflected in the list of perils. Normally exclusions are on a different vector, if you like, and that's the point. So there will be overlap inevitably, because that's otherwise there's no point having an exclusion. I mean, sometimes you have one as belt and braces just to make sure something isn't covered. But the most, obviously the exclusions that may bite are the ones that have some kind of overlap. But the overlap never takes the form in an ordinary exclusion of saying, you know, that list of covered perils, well, that one are not covered. That's just not what exclusions do. They're on a different plane.
Except 5.2.1.
Yes, my lord is quite right, of course, except 5.2.1, which is a belt and braces type of exclusion, saying the one that we've marked as excluded on the cover spreadsheet is excluded. I mean, there could be an argument, I suppose, if a different loss arose as to if you had.
Your point is that you set out the exclusions on the premise that there is cover.
Yes, that's true, and indeed it's a point my learned friend makes, is well that the exclusions must relate to covered obligations, otherwise there's no point having them. But actually, as Meinhold points out to me, number one is in fact of things that are not covered. So you can sometimes have belt and braces. But I agree, I accept that exclusions bite when they are in respect of something that might otherwise be covered. But my point is that most exclusions are not a contradiction, because most exclusions are in that form where they operate on a different plane, and they say that peril is still generally covered, but certain loss caused by that peril is excluded, or if the peril operates in conjunction with another peril and they're both proximate causes, then the exclusion bites. And of course you can have an argument about whether proximate cause is the relevant test of causation given a particular clause.
Do you say that the inclusion there of 5.2.1 indicates that the other 15 exclusions are not excluding insured obligations as a whole?
I've not put that as an important argument, but it is true that if you read 5.2, you are reminded that insured obligations which are intended to be wholly excluded are marked as excluded. And the draftsman of the exclusions is aware of that, if you were to try and sort of divide it up. So there is something there. It is all consistent with the way I seek to read this policy. But then, as you know, if the insurers are right about the way it is to be read, exclusion 15 does remove all cover for warranty 13.5. And to understand that, we have to look at the definition of ABC liability, which is on page 192.
Before we leave 5.2.1, isn't it further important for you because the reference there to excluded must be to the cover sheet?
Yes. That's certainly right, my lord. Excluded insured obligations are those that they're defined, and they are those that are marked as excluded.
So not only is the cover sheet integral to the cover, it's also integral to the exclusions.
Yes, I mean, that's right, my lord. I mean, save for the insurer's reading of exclusion 15, my case is that this policy does hang together and make sense. And so the only inconsistency I am alleging is that if the insurers are right about how you read 15, then that creates an inconsistency. And I say that shows they must be wrong. But I entirely accept my lord's point.
I mean, the point is that, I think your point is that to ignore the cover sheet isn't just saying, oh, well, we ignore something which is tacked on at the end. It is to ignore the very fundamental bricks upon which both cover and exclusion are built.
Yes, absolutely, my lord. That is right. So the definition of ABC liability on page 192, any liability or actual or alleged non-compliance by any member of the target group or any agent, affiliate or other third party in respect of ABC laws, which are then defined in the next definition, all laws and regulations in relation to quite a wide range of things: anti-bribery, anti-corruption, anti-money laundering, counter-terrorist financing, financial sanctions, export control, other aspects of financial crime. So it's very wide. And insurers say, you read those words of the definition literally, with an emphasis on that first or, so that it excludes any loss that could arise from any actual or alleged non-compliance with ABC laws. It was not in dispute before the judge that that would have the effect of removing any cover for warranty 13.5. I don't understand it to be in
How does
dispute
that work
today.
on something like the record of hospitality and gifts?
My lord, I can see that. Let me put it this way: there are three responses I make to that. The first response is, it doesn't actually matter for my purpose if one of the 8 turns out not to be fully contradicted, because I've still got 7 others. The second response is, it's actually rather hard to imagine the lack of records causing loss unless there is an actual or alleged breach of one of the regulations. Very hard to see how you'd ever get loss. And the third point is that my learned friends have never actually suggested that there's any cover that could be granted. Despite this having been an issue on the pleadings, they've never come up with anything. So, my lords, that's my 3 responses to the point. I do see the point that the records, perhaps more than any others, you could say, well, there could be a breach of that. But it is hard to see how it's ever going to cause loss unless there is underlying it some actual or alleged breach of the regulations.
Just pausing on the definitions of ABC liability.
Yes.
The liability referred to, I take it, is the liability of the target company. Is that right?
That's certainly going to be the core meaning. It does depend how you read the ors, if you're in terms of whether you then get to any member of the target group or agent, affiliate, or other third party. So, my lord, certainly that's certainly the core of what is being got at, is that the target company itself may have liabilities, and certainly we say that's absolutely the core of it. On my construction, that's very much the core of it.
So again, the loss is the diminution in value of the shares.
Yes.
The liability is the liability of the target or affiliates.
Yes.
And they may or may not be the same.
Yes, exactly. That's right, my lord. A point which the judge appears to have not understood, which I'll come to in a moment, a few moments. And my lords, that was what I wanted to say about how one reads the policy, and then we go to ground 1.
Well, just on the question about hospitality and gifts, I mean, I haven't really thought this through, but I mean, part of the point of a record of hospitality and gifts is yes, of course, it's relevant for things like fire and corruption, but it also goes to the financial health of the company, doesn't it? Because if you don't have proper records of things like that, you may discover that there's a bit of a hole in your balance sheet.
Well, my lord, I submit that that's not a sort of realistic way of looking at this. There are, of course, other warranties of the financial condition of the company. And one would hope that recordable gifts were not such significant value that they are actually going to impact on the financial condition of the company. I mean, I can see, one would hope they wouldn't normally be. So that's not what this warranty is directed at. There are financial warranties. I mean, I think I showed you number 1 just because it was the first one on the list. This is, in my submission, not about that. I mean, the warranties are separated into their separate purposes. So, what I've shown you in my submission is that each of the 8 subparagraphs is individually defined as an insured obligation, and it follows that the policy states that loss arising from the breach of each of those 8 is covered. And if the words of exclusion 15 are construed as the insurers and the judge would construe them, then they contradict what I've just said. They contradict the definition in the cover spreadsheet because they exclude all the loss that would arise from the breach of each of those subparagraphs. And as I say, I emphasise each, because even if there was an argument that 1 or 2 of them were harder to fit into that, then there's still another 7 or 8 that do. The proposition, therefore, that insurer's construction leads to a contradiction is, in my submission, entirely straightforward. The policy states in terms, warranty 13.5A is covered, and insurers say that the exclusion states in terms that it is not covered. So that is a contradiction. So I turn then to look at what's said against me in the judgment and in my learned friend's skeleton argument. I'm going to look at the judgment now, so your lordships may want to close bundle B, although of course we'll come back to it, but it's in, I've got it in bundle A, I don't know if my lords have taken it out, but it's in A tab 5, starting at page 30, and the point as to contradiction is discussed in the judgment starting at paragraph 39 on page 50 of the bundle. And the judge's first reason for rejecting the argument that there's a contradiction is at paragraph 40, where he says an ordinary insured could not reach any conclusion about the effect of the cover spreadsheet without considering the definitions in clause 1 and the insuring provision in clause 3. Well, I don't dispute that, as you've seen, but I don't understand the conclusion he then reaches at paragraph 40, that shows the defendant's approach to reading the policy is to be preferred, because our own proposed reading starts with the insuring clause and then goes to the relevant definitions. So we agree with the judge that you need to read the insuring clause, you need to read the relevant definitions. So that's equally consistent with either side's case about how you read the policy. So I don't understand that.
I'm not sure the judge really confronts the question of contradiction.
My lord, yes. I accept that he never really confronts it, but I'm obviously dealing with what he does say that he says goes to it, essentially to make that point probably slightly more wordly. But since I can't assume that all of your lordships accept it, I need to develop it. But I do say that, my lord, yes. He doesn't really confront it. And he then refers to the relevant definitions at paragraph 41, making clear what he means at paragraph 40. And he then concludes at paragraph 42 that exclusions can only apply to an obligation that's otherwise covered. And I've made my submissions on that point, that again, in a certain sense, I accept it. That's right. It doesn't excuse what I say is a contradiction. And then at paragraph, at paragraph 42, the final conclusion, though, such an exclusion can apply only to an obligation that's otherwise covered, is misstated. The judge concertinas some of the concepts here in a way that does appear to then affect his reasoning. So it's right that an exclusion won't bite on a claim unless the claim would otherwise be covered. So the claim has to involve a covered obligation. So it's for loss arising from a peril which is covered. And in this case, the peril is a breach of an insured obligation. But what may be excluded is not the insured obligation. That's not what's excluded. What's excluded is certain loss that might arise from the breach. So when the judge says the exclusion can apply only to an obligation that's otherwise covered, he does appear to be either expressing the matter in shorthand or not quite stating it right. And it looks from what he says later that he may be not quite stating it right.
So you say when he says obligation, what he should be talking about is loss.
Yes. Yes. And so that, on the face of it, that may just be a quibble, but one has to then look at the rest of what he says. And if you then read paragraph 43, he follows through the policy wording and reaches a conclusion which is in line with my approach. The end of 43, it necessarily follows that loss from what would otherwise be an insured obligation may nevertheless be excluded from cover by operation of clause 5. And apart from the fact that he's taken out the word certain, I accept that, because he's been using the definitions. But then at 44, he draws it together, he says, and reverts to the erroneous formulation that if an obligation is covered, then that obligation may be excluded. You can see that in the middle of 44. If an obligation is marked as covered, it comes within the scope of the insuring provision, but subject to it being otherwise excluded by the operation of clause 5. And that is the reasoning that leads him to say in the last sentence of 44, the policy is not self-contradictory. So most of the reasoning is in many ways consistent with how I say the policy should be read. But whenever the judge moves away from the policy wording and concertinas the matter, that's when he conflates two different propositions, with the result he gets to the wrong answer on this question. The proposition that is supported by the policy is that for any given insured obligation, certain loss arising from the breach of that obligation is indemnified, but certain such loss may be excluded. And that is in the policy wording. The proposition that's not supported by the policy wording is all loss caused by certain insured obligations may not be indemnified if those insured obligations are excluded by clause 5. And that's how the judge reaches the conclusion that there's no inconsistency by not distinguishing between those two formulations. So the question on ground 1, as far as the judgment is concerned, is whether I'm right that there is actually a distinction to be drawn between excluding certain loss and excluding an insured obligation. And if I am right, then the judgment does not have reasoning to justify the conclusion that there's no contradiction. So I'm then going to deal, if I may, with what my learned friends say about why there's no contradiction in their skeleton argument, which they deal with in their, I'm not sure where my lords have this, there's a replacement skeleton in the supplemental core bundle, which is a small bundle. You may have had it separately, but when you were asked to put it in a bundle. So it's tab 1 of that. And ground 1 is addressed between paragraphs 15 and 33. But I can take it more quickly than it sounds, because paragraphs 15 to 25 are not concerned with the question whether there's a contradiction. They're concerned with the question whether the policy can be made to work without any correction. So I skip over those paragraphs because they're not actually about ground 1. But at paragraph 26, my learned friends defend the judge's agreement with their suggestion that the policy should simply be read from page 1 through to the end. I disagree with that, but I do agree with them at paragraph 27 that ultimately the meaning of the document is not determined by the order in which you read it, because we all know it's an iterative process. The order is just one factor that explains how it works, but it's not determinative. Paragraph 28 begins with 3 sentences that make the point that we only identify one contradiction and our appeal depends on that. Well, as you know, I say there are 8 contradictions, not just one. But in the last sentence, my learned friends say something that I do need to address. They submit that it is mistaken to view the cover spreadsheet as being of equal importance to the insuring clauses, as they put it, and the policy exclusions. And I have, in fact, made it clear that I disagree with that already in answer to questions from my Lord Justice Phillips. But I submit there is only one insuring clause, 3.1. I'm not sure what their clauses are. The cover spreadsheet is actually part of that insuring clause. It defines the insured perils and is therefore the heart of the policy, as we call it in our skeleton, the commercial heart. And I adopt my Lord's point that it is in fact referred to in the exclusions themselves. And it follows that it is of at least equal importance with any other provision in the policy. My learned friends then, at paragraphs 29 to 31, do make arguments against the proposition that there's a contradiction. And at paragraph 29, they argue that the rubric establishes that the cover spreadsheet is entirely subject to the exclusions in the policy.
Sorry to interrupt you, Mr. Salzito. Aren't there essentially 3 stages in this argument? The first is there an apparent contradiction between the exclusions and the cover sheet? And by interpreting the policy, you may say, yes, there is, or no, there isn't. If you say, yes, there is a contradiction between the exclusions and the cover sheet, the next question is there anything in the contract which tells you which is to prevail? And I mean, there are well-known techniques for indicating whether clause A is to prevail over clause B, vice versa, or vice versa. So you can say clause B is subject to clause A, or clause B has effect notwithstanding clause A, or various other formulations. So the contract tells you the order of precedence, if you like. And very often it says that the terms of this contract apply unless inconsistent with something else. So you've got a clue in the contract. So that's, as it were, stage 2. And there are some general propositions which courts apply from time to time, like specially negotiated clauses prevail over boilerplate clauses and so forth. If you find that there is a contradiction which the contract doesn't, and then the contract doesn't tell you how to solve it, you then get to stage 3, which is, well, what then does the court do about it? And the first 2 stages, speaking for myself, I think shouldn't be elided.
Yes. My lord, yes, I accept all of that. I accept all of that. That's right. And I accept, I think to some extent I'm perhaps almost as guilty as my learned friend of going straight to this question of what the rubric means, which is because it is part and parcel of the cover spreadsheet. But I do accept that in a sense, the first question is there an apparent contradiction? And my argument, and that's why my argument on ground 1 itself is so very short and simple.
Yeah.
There is, at least on insurer's construction, an apparent contradiction. We do then get
Because I think paragraph 29 in the respondent skeleton is in effect addressing the second stage.
Yes.
The contract tells you how to resolve an apparent contradiction.
Yes, I mean, that is true, my lord, although I think in defence of both of us, there is, of course, the iterative element of all
Yes.
this, that in a sense it has to be understood as a whole document. And part of that will be how does one read what may be contended to be a clause for some clauses to prevail over others. So in a sense it's part of that, and it's part of my overall argument that there shouldn't be this kind of contradiction and therefore it should be resolved, that the policy is actually makes perfect sense, including the rubric about how the clauses do interact. Now, your lordship is right that that looking at it step by step, first question is there an apparent contradiction? If so, does the contract tell you that it doesn't matter because one clause beats the other? And if not, what does the court do about it? So I do accept that framework. And I also accept that what I'm coming to now is effectively on that question 2, where my learned friend says, he does say there is no contradiction. Yeah. Because the cover spreadsheet itself says anything in here which is contradicted elsewhere doesn't apply. Yeah. Effectively. So you sort of you can dance on the head of a pin about whether that means there is or is not a contradiction, and I'm not too concerned really by that particular debate. But of course I am concerned to deal with whether this rubric favours my learned friend's argument or favours mine. And he says it establishes that the cover spreadsheet is entirely subject to the exclusions in the policy. But of course those are not the words used. The words used are then quoted at the end of paragraph 29, and my learned friends have highlighted most of the words and unhighlighted 2 phrases. I've got no concerns with their unhighlighting of the last 3 words of the policy, which don't actually change anything, but the unhighlighting of the other phrase, arising from the breach of such an insured obligation, in my submission does matter, because those words qualify certain loss and they provide the necessary context in which an ordinary reader understands what certain loss means. It's not just certain loss, it's certain loss arising from the breach of a particular insured obligation. And that gives it sense, directs attention to each insured obligation which is marked as covered or partially covered. And the rubric says certain loss arising from breach of such insured obligation may be excluded. And I say the ordinary English meaning of that is clear and does not say what my learned friend says it says. My learned friend then go on at paragraph 30 to state that the words show that the exclusion should prevail. And of course that's another gloss on the words, they don't say that. And the submission I was going to make is rather perhaps in line with the point that my Lord Presiding has just put to me, that when my learned friends say prevail, that's actually quite indicative, because prevail implies a conflict. One side prevails over another, one provision prevails over another if they are in conflict, or as perhaps my learned friend would say, otherwise in conflict. And my learned friends essentially say, well, that's the nature of exclusions, they prevail. And we say that's true only up to a point, and I've made those submissions.
I'm sure it's my fault, but it's right. Yes, 4 lines up from the bottom is where you say you're pointing to. ABC exclusion prevails over the current spreadsheet. Okay.
Yes. I'm sorry, my lord. I should have pointed to where it is. Yeah.
But that is in the context of if there was an apparent contradiction. Because that's what they say. They say even if there were an apparent contradiction, i.e. contrary to their argument, the contract provides the answer as to how to resolve it. The ABC exclusion prevails.
Yes, I mean here they are saying no contradiction can arise because it's clear which one prevails. I mean, I'm not sure, my lord. I mean, on their construction.
Well, I'm sorry, I don't see the problem. I'm not sure it matters, but as I see it, they're making 2 points. One, they dispute there's a contradiction, and then they say in the alternative, even if there is a contradiction, and this is my lord's question too, the contract gives you the answer as to how to resolve it.
Well, I'm sure my learned friends might say that, but my lord, I am going through their argument for there being no contradiction, and so far I haven't identified anything which actually disputes that on their construction there would be a prima facie contradiction, but one which on their argument is resolved by what they say is the primacy of the exclusions. But my learned friend, I'm sure, will speak rather better on his own behalf than I have. They argue then at 31 again about the phrase certain loss, saying it's not equivalent to a part rather than a whole, and that's where the context is important. I say in how you read it, so as I said earlier, we dispute how you read it in ordinary English. Then at 32, they say it's clear the cover spreadsheet is intended to be subsidiary to the rest of the policy, and I say that that argument does take a prima facie contradiction as its premise. That's why I'm afraid I'm not accepting the point being put to me that my learned friends actually have an argument that there's no contradiction at all. My learned friends argue that the resolution is to override the definition of warranty 13.5 as an insured obligation on the ground that exclusion 15 is structurally superior. And again, if one looks at 32 lines 4 to 7, where my learned friends say, even if one ignored the clause at the introduction of the cover spreadsheet as set out above, and there was perceived to be some sort of conflict, it's plain that the exclusion has primacy over the cover spreadsheet. So again, my lord, I am not convinced that they're actually arguing that there's no prima facie contradiction, but we'll see. I may have missed something. I'll come back to it in reply. And secondly, they rely on the argument that the structure and hierarchy of the policy puts the exclusion first. And that point does seem to depend on what order you read everything in. And if it matters at all, I submit it should be read as I read it, with the exclusion coming after you've seen what's covered. But more importantly than what page numbers you read first, much more importantly, is that conceptually cover comes before exclusions. That's the structure of any insurance policy. The perils are identified, subject to conditions. Some of the conditions may be exclusions. So structurally speaking, the cover comes first. So I say that the second factor that my learned friends rely on in this regard, that's to say the structure and hierarchy, actually favours me quite strongly, and it's quite an important point. And thirdly, paragraph 32, they say that the cover spreadsheet sets out terms to be covered subject to the policy wording, unlike the exclusion, which is not subject to anything. Now, of course, I accept that all of the.
I was making a note. Where are you now?
I'm in. I hope I'm in paragraph 32. Yes,
32,
in 32, I invited attention to those words between lines 4 and 7, even if one ignored.
Yes.
And then they say this is based on :
Yes.
And there are then 3 points. One, it was a special term.
Mhm.
Actually, I didn't deal with the special term. I'm sure I was going to deal with the special term. Oh, yes, I've missed in my notes. Okay, 1, it was a special term. My lords, that's a score draw, because both the individual marking of warranties as covered and the exclusions are special terms. They're both individually decided upon and negotiated. No dispute about that. 2, structure and hierarchy after the first semicolon, I have just dealt with that. And then 3, and the cover spreadsheet sets out the terms to be covered, but which are subject to all the policy wording, in contrast to the ABC exclusion, which reflects a focused and deliberate decision to exclude an identified risk. And I say that that one's a no score draw, because of course the cover is subject to the terms and conditions of the policy. It'd be a very strange cover if it wasn't, but that just takes you back to the need to construe the whole document together. Clause 5 does not have any of the special wording that my Lord Justice Lewison was putting to me as maybe included in a policy. It doesn't have special wording saying these exclusions prevail over any contrary indication in the policy or anything of that sort. So this is a no score draw. Neither the cover spreadsheet nor the exclusion provision has anything to say that it is not generally subject to all the other terms and conditions. They both are. And my learned friends then refer to 2 authorities at the bottom of their paragraph 32. I'm not planning to turn those up myself now, but I summarise their effect very briefly, if I may, which is they support the proposition that if there is a contradiction, one possible resolution is to find that one conflicting clause should prevail over the other. And that's not in dispute, it's the basis of my ground 3. But they do not actually assist on ground 1, which is whether there is a contradiction at all. So, my lords, that covers what I wanted to say about ground 1. I've shown your lordships the contradiction, and I've dealt with why the judge said there wasn't, and why my learned friend, or what my learned friends say under the heading of ground 1. Ground 2 is that the contradiction could and should have been resolved by corrective construction, in this case, by reading the definition of ABC liability with the alteration of the first or to for, so the addition of the single letter F. I don't know if my lords may want to go back now to tab B just to see it, or if your lordships are familiar with the argument from looking at the skeletons, but I'm not going to, I'm going to go to...
Can I just ask you a question about this? Because is it the thesis of your argument that the definition contains a typographical error?
The thesis of my argument is that I say that the best way to deal with the apparent contradiction is by corrective construction. So the thesis that I need is that something has gone wrong. Whether that something is best described as typographical, I mean, my submission is it probably is, but there is no material upon which the court can determine. And the authorities do not suggest that the court needs to determine whether what has gone wrong is a typographical error or anything else. Indeed, the authorities on error correction say that one doesn't even have to do it by writing in a word or deleting a word. What's important is that it's clear what concept the parties intended to agree. And if it's clear that that's not reflected by that literal...
That's why I'm asking the question, because, I mean, one of the authorities that referred to is DNA nudge.
Yes.
And what had gone wrong there was that what was thought to be obvious to the drafter was not actually expressly stated, namely the relationship between the 2 clauses. One was plainly intended to be subordinate to the other, but because that was so obvious to the draftsperson, they hadn't actually written that in. And so that was why corrective construction was appropriate, because it was spelling out what was actually obvious. And that's why the alternative legal answer to the problem was implied term.
Yes.
Whereas you can't, I don't think, say that that kind of approach applies in this case.
No, I accept that, my lord. I
And
accept.
so therefore one's asking, well, what is the nature of the error? And that's why I ask you, do you say it's a typographical error, or is there some other type of error that it could be?
No, I mean, I do say it's a typographical error, but I do not ask the court to make a finding. There's no material on which the court can make that finding other than sort of pure logic, that if you're with me, that this can't be what was intended to be agreed, and you're with me on ground two, that the obvious correction is that it should be liability for, then you may say, well, it's clearly a typographical error. I mean, it is my submission that it's probably a typographical error, but I submit that I don't need the court to make that finding for me to be right, for my appeal to succeed. And I accept it's quite different to the DNA nudge situation. And of course, that's why I'm not running implied term as an alternative. I'm not saying there's an alternative implied term that could be implied here. Either I'm right that it should say for, or this is one of these exclusions which has to be ignored because it just contradicts the cover. That's why my appeal has the three grounds it has.
Well, let's suppose you're right on ground one. There is a contradiction between the exclusion of ABC liability on the one hand and the cover sheet on the other. One solution, possibly, is to adapt the wording of the definition in the way you suggest. Another is to remove the word certain from the rubric of the cover sheet. And a third is to remove the ticks from the cover sheet. Now, why should we choose one rather than the other?
Well, I'm not sure what your lordship means by the ticks. If you mean the words covered and change them
I'm sorry,
to excluded.
covered, yes. Covered.
Yes, you could change the 8 words covered
Yes.
to excluded,
Yes.
and that would
So,
resolve the contradiction.
What has gone wrong may be in the cover sheet, or it may be in the definition, or it may be somewhere else.
Maybe, my lord, and obviously that's what I'm coming to in grounds 2 and 3. That I say that I do say that that it looks as if there's simply an error in the definition of ABC liability, and that is one way of doing it. But the other is if you're not with me, that's clearly the error that's been made, because on corrective construction, as you know, I have to show that there's only one error. If you're not with me on that, then you've got the situation where you've got a policy that has 8 individual warranties marked as covered, and an exclusion which appears to contradict that. And in that case, the authorities suggest that the approach is you ignore the exclusion. And if you wanted to put that into the framework of general contractual construction, you'd say it's because the fundamental purpose of the policy is to give cover for certain perils. So that's the fundamental purpose. And if a clause in the policy is abhorrent to that or contradicts that, then it's that clause that has to give way. But in fact, it seems to be a more specific.
This is why I was asking whether it was your case that it was a typographical error, because one can imagine the possibility that someone is intending to write for, misses out the F and writes or. But the counter argument is, no, this is deliberately disjunctive. And so one view of this case, I'm not saying it's the only view, but one view of this case is what the court has to weigh up the likelihood that it's a typographical error against the likelihood that it's deliberately disjunctive.
I can see that's one way of putting it, my lord, but the difficulty with that way of looking at it is that, and it's why I wasn't quick to adopt the idea that my submission is it's a typographical error, is because whether it's a typographical error or not is ultimately a question of fact, which this court has no materials to resolve. And so if you then say to the question, well, what's more probable? You're addressing, well, on the balance of probabilities, did the draftsman make this mistake? There is no material to resolve that other than the words of the contract. So what one then gets back to is well, how would somebody understand the whole contract? All of my arguments have to start from the contract. I mean, in its context, but I'm not relying on external material. So
What to be sure, absolutely, I take your point. We look at the contract as a whole, and your whole argument is that looking at it as a whole, you are driven to the conclusion that something has gone wrong in the wording.
Yes.
But the reason why I'm harping on about this question is, doesn't that entail an inquiry as to what's gone wrong with the wording?
Well, if on my ground two, where I asked for it to be corrected, it does entail an inquiry into what's gone wrong in the conceptual sense, in the sense what was it these parties did intend. And I say that actually it's straightforward, because if you just read any liability for, you get what in my submission makes perfect sense in the policy, probably is a typographical error, and is what these parties intended. And so I do say that, but it's not, I submit that I do not have to persuade the court that on the balance of probabilities, the nature of the error is typographical. What I have to persuade the court is that the way in which an ordinary person would read this would be with a for rather than an or. And if I fail on that, then I have to go to ground three.
Well, the questions here, I think, are, is there an obvious error?
Yep.
And if so, is it obvious what the correction should be?
Yes, is it clear what the correction should be? Yes. That's right. It is right, my lord. And there are different starting points. And it is possible to start by saying, well, look at that definition. It obviously means any liability for something. And if you just put in a for there, then it all works. So that must be what was intended. And indeed, somebody reading it quickly may well read it as any liability for, because that's what you expect to see after the word liability. So I do submit that this is the obvious correction to make, and that this is what these parties intended. It makes perfect sense of the whole thing. So they're not going to pick up loss which arises directly from or rises from liabilities incurred by the target for
Yes,
anti-bribery.
but the counter argument is, from the insurer's perspective, is they would have had good commercial reasons for excluding.
Well, exactly, but the good commercial reasons is another one of these score draws, because we obviously want the maximum cover, they want the minimum cover.
Yeah.
To be sure. So each side has good commercial reasons for the right of all potential wordings. And so how does one then decide whether there's an obvious error?
From the rest of the policy, my lord.
Yeah.
And so, I do say it is incredibly important that the cover spreadsheet marks each of these eight warranties as covered, when the whole purpose of the cover spreadsheet is to mark each of them as being either covered, partially covered, or excluded. It is important to somebody reading this document that they understand there is cover for those warranties. The fact that it's done individually is important. So I accept completely, if one just had this in isolation, with no background and no other words in the policy, my position would be a lot more difficult. My position is based on reading the whole policy.
What I'd say, I wonder whether when you put the case as one of contradiction, whether you're slightly underselling it from your own point of view. Because as I understand your argument, and it seems to be the case, the structure of the policy is that cover is, by virtue of the terms, excluded insured obligations and insured obligations, insured signing obligations, is defined by whether or not it is shown as covered or excluded in the spreadsheet, the cover spreadsheet.
Yes.
So that is the fundamental definition of cover here. Whereas the exclusions are expressly addressing what loss is not covered.
Yes.
Based upon cover. So if on the defendant's construction they construe an exclusion as actually excluding cover, it's not just an inconsistency, it's a perversion of the structure of the policy. And contradicts it's not a contradiction between between two clauses, but it actually doesn't make sense internally in the structure of the policy.
I mean, yes, my lord, but I think my learned friend might say that his argument doesn't actually attempt to skip over loss. I mean, I say that some parts of his argument do, but his construction is could still be fitted within the right framework by saying all loss. So what he's excluding, I think, let me see if this works. So he says that what is excluded is any loss to the extent that it arises out of any liability or any actual non-compliance or any alleged non-compliance. So I think he would say it's sort of in a sort of way coincidence in terms of language anyway, that just excludes the whole of warranty 13.5. I think he would say that there isn't a separate point, if I've understood what your lordship is putting to me, for me, that he's really trying to exclude cover rather than loss. He would say, I am excluding loss, but I'm just happen to be excluding all
That's
loss.
what, I mean, he accepts that effectively is what it amounts to, because that's why he has to relegate the cover sheet.
He does accept that's what it's amounts to, yes.
Yes. So, given that acceptance, I'd have thought you can say, can't you, that his construction doesn't just mean there's a contradiction. It means that effectively he's reading an exclusion of loss as though it was an excluded obligation.
Yes, my lord. I hope I am making that point, and perhaps in two different ways, but more in relation. I think making it in relation to ground one in demonstrating there is a contradiction, and I will make it in relation to ground three in saying if I can't correct, then it's the cover that dominates.
I think where it's important, I think, is in relation to the point my lord, or Justice Lewison put to you, as to what else could you do to correct this contradiction. And it's put to you, well, you could rewrite the cover sheet. But I think that, on this point, that I think is a misunderstanding of the problem. The problem isn't a contradiction which you can fix by fixing either end. It's a more fundamental problem, which is that the defendant's construction undermines the whole structure of the policy, which can only be addressed by reading the exclusion so that it doesn't amount to an exclusion of an insured obligation.
Yes. Well, my lord, I do agree with that, and I hope it's consistent with what I've been saying. And obviously, to the extent your lordship puts it better, then I adopt the way your lordship puts it, because I do entirely accept that. That is very much my argument, that one has to that the structure. Well, I won't try and put it again, because I'm probably not putting it quite as well. But my lord, yes, I do accept that. I do adopt that. So my lords, I've got rather shorter submissions to make, I think, on ground 2 and ground 3, but I do need to perhaps deal with the judgment and skirt on that. I wonder if the transcriber would probably
I'm
like a
afraid one
break.
of the conditions of allowing the transcript is there are no breaks.
Oh, thank you, my lord. I apologise for not having been aware of that. So on ground 2, I wasn't actually going to say much about the law because there doesn't seem to be any real dispute about it. I was going to point out to my lords that we've each referred to the same paragraph of Lord Justice Nugee and Monsola and tell you that that's in tab 7 at page 262. But as you know, that's a summary of what Lord Hoffman said in Chartbrook. So is it clear that a mistake's been made? Is it clear what the provision was intended to say? A contradiction is a mistake. Now, I don't know whether the court needs any persuading of that, but Mr. Justice Foxton's decision in Generali Italia includes a rather striking example of where there's a contradiction, and he goes on to then deal with corrective construction. I don't know if your lordships will find it helpful to see that or not. But,
If you think we will be helped by it, we will look at it.
yeah, well, it's simply on that point, so I will look at it quickly if we may. It's Authorities tab 17. This was a decision which involved looking at a number of conflicting jurisdiction clauses, and I only want to look at a very small part of this on page 584 of the bundle, which is 4237 of the report, and Just on the previous page, there's a new subheading, India International, where he's dealing with a particular conflict. And paragraph 107 contains this rather striking contradiction between English law and jurisdiction and Italian law and jurisdiction. You can just see that quoted at 107. And Mr. Justice Foxton, paragraphs 108 to 110 sets out that in the case of such a contradiction, that is something which can justify corrective construction.
Yes.
And in my submission, the same is true of DNA nudge. In tab 9, although I've already accepted, of course, it's a slightly different situation, but nevertheless, the structure of the reasoning of Lord Justice Snowdon, with whom my Lord Justice Arnold and Lord Justice B agreed, I've got mine in one bundle, so I don't actually know where your lordships need to change bundles of
My
authority.
first bundle is 1 to 11.
1 to 11, thank you. I'll try and remember that. So we tab 9 is DNA nudge, and there's a short summary of what it's about in paragraph 1 of the judgment, page 294 of the bundle. A conversion of shares held to be of no effect because it had not received consent in writing. And then if we just go to page 296, paragraph 12, article 9 of the articles at 9.2a stated all Series A shares shall automatically convert into ordinary shares, A, upon notice in writing from an investor majority at the date of such notice. And then on the next page, paragraph 15 of the judgment, article 10 provided, wherever the share capital is divided into different classes, the special rights attached to any such class may only be varied or abrogated with the consent in writing of the holders of more than 75% of the shares of that class. And in short, the investor majority triggered an automatic conversion. The holders of the Series A shares had not consented under clause 10 and did not wish to do so. The judge held the conversion was void, and this court agreed. And if we go to page 305 of the bundle, paragraphs 44 to 47, your lordships, maybe we just, I know you've read 46 and 47, but if you just quickly look over 44 to 47. The point that I seek to take from those paragraphs is that coherence of the contract is an important aspect of...
Just to make good the point I was drawing attention to earlier, if we look at paragraph 99, which is the actual conclusion,
Yes.
what it said is the judge was right to read this conclusion in order to make rational and coherent sense of the articles. Either Article 9.2a must be interpreted as being subject to Article 10.1, or a term must be applied to that effect. Either way, the result is the same.
Yes.
And that supports what I was saying earlier, that this was a case where the draftsperson had omitted to say in 9.2a, subject to 10.1. and therefore there were two routes to the same conclusion, either corrective construction or implied term. But that's because what had gone wrong in the drafting was expressly saying that obvious thing.
Yes, well, I see that, my lord, and I'm not seeking to draw a sort of close analogy between the particular contract in that case and the one in this case. What I'm seeking to rely on in this authority for is the proposition that the coherence of the contract is one of the things that the court looks for, and one of the things that is relevant to error correction and may lead to error correction if it's otherwise incoherent. And if one, and this case is also quite helpful because it involves the same structure of the argument in the sense that the incoherence arises on one party's construction.
Yeah.
And that's a similar situation here. So I was going to draw attention also on that, on the point that I'm trying to extract from it. Paragraph 63 on page 308. The judge was entitled to investigate whether the rival meanings were consistent with other provisions of the articles and ask whether they produced a coherent and commercially sensible scheme for the articles as a whole. And I say that that's of some relevance in our case. And paragraph 78 again emphasises incoherence, not just irrational. So it can be incoherent or irrational. And I say that's relevant. And then, as we know, paragraph 81, the judge did use corrective construction, and paragraph 99, as my lord has pointed out, this court said the judge was right to do so, or to imply a term. So, in both of the two cases I've shown you, we simply see the point that a contradiction is something that tends to show something's gone wrong with the drafting and can justify corrective construction. The first question, whether something's gone wrong. The second question then is it clear what correction is required? And we say that it is obvious that the correction is to read the definition of ABC liability as any liability for. And we give 4 reasons for this in our skeleton argument at paragraph 38. And I'd like to shortly develop those 4 reasons, if I may. If your lordship's like me, it's the skeletons in the bundle, it's core bundle A, tab 14.
Yeah.
So the first reason we give is that if it's read entirely literally, the definition becomes not a definition of a liability, it becomes a definition of many other things. And that's not what a reasonable reader will expect to find when they're reading a definition of a liability. Whereas on our reading, it immediately becomes a definition of a liability, and we cite Chartbrook for the proposition that labels are generally not arbitrary. I think it may be worth picking that up because it's significant in my argument that it is possible to correct this within the ordinary rules. Chartbrook at Authorities 1, tab 1. The paragraph that includes the words we quote is paragraph 17, where in relation to Chartbrook, it's Lord Hoffman says that the labels are seldom arbitrary, they're a distillation of the meaning of the concept, and they be more precisely stated in the definition, which was relevant to his approach to which of the two constructions were right on that case. And I wanted also perhaps just to look quickly at paragraph 20 on the next page, the second half of that paragraph. The striking feature of this case is not merely that the provisions as interpreted by the judge and the Court of Appeal are favourable to Chartbrook. It is that they make the structure and language of the various provisions of Schedule 6 appear arbitrary and irrational, where it's possible for the concepts employed by the parties, MG, UV, CNI, etc., to be combined in a rational way. And of course that, and this may be in part part of my adoption of what my Lord Justice Phillips was putting to me, but I say that this is one of the problems with the insurer's construction, is it makes the structure and language seem arbitrary and irrational. Why would you mark some as covered and then say that they're not really covered? And why would you define a liability which then turns out to be something massively broader than a liability? The next page, 22 to 25, which is sidelined, so my lords have read it, is the classic explanation of corrective interpretation. So I'm not asking you to dwell on that further. So the second aspect of our submission, that the correction will match the label, is that it actually goes a bit further. On the, if we just go back to, so I think I see how long I'm putting away the authorities. I'm putting away the authorities at least for a couple of pages of my notes. On the definition of ABC liability in Bundle B, tab 2, page 192, if we read it.
Sorry, I'm behind you. What are
Yes,
we going?
sorry.
We're going back to the policy.
Yes, please. Bundle B, tab 2, page 192.
Yeah.
If we read it as meaning literally that any liability or actual or alleged non-compliance, the result of that is not only that it's more than a liability, but that the liability aspect becomes completely superfluous and falls away. Because if the exclusion excludes all loss arising from any actual or alleged non-compliance with ABC laws, well, that would itself exclude any liability arising from
Wait
it.
a minute. The starting point here, I would have thought, is clause 5.2.
Yes?
The underwriter shall not be liable to pay any loss to the extent that it arises out of any ABC liability.
Yes.
So, expanding clause 5.2, the underwriter shall not be liable to pay any loss to the extent that it arises out of any liability or actual or alleged non-compliance by any member of the target group, blah, blah, in respect of ABC laws.
Yes.
Now, if you expand it in that way, the judge's interpretation at, I think it's paragraph 38 of the judgment, does make sense. It's loss, that is to say, a diminution in the share value arising out of an alleged non-compliance with ABC laws, which may or may not be a liability of the target. It's an allegation. So the main customer says, we're not doing business with you anymore because we've heard these rumours that you're corrupt.
Yes.
Now
Yes,
that may or may not be true.
Yes. No, I accept that, my lord. I accept that on the completely literal construction, the policy can work.
Yeah.
I do accept that, but it works in a way which is irrational and incoherent because it doesn't make any sense.
That's back to the contradiction
Yes,
point. Yeah.
it is. So I accept that, my lord. And at the moment, I'm supporting my submission as to what the actual correction is by saying that that there are two aspects to the problem that ABC liability should be defining a liability and is not. The first aspect is obvious, that it defines something much bigger than a liability. It's a liability or something else.
Can I just ask you about that? Because the starting point here was you were relying upon what Lord Hoffman had said in Childproof.
Yes.
And your point, which I perfectly understand, is that the choice of the label ABC liability can't be accidental. It was that label was chosen by the parties, chosen deliberately, and it gives us a good flavour of what they were intending to cover. And I understand that argument, but can I ask you this? If we look at 5.2, where conveniently they're all listed, we can see that all of these labels are as short and snappy as possible. So, for example, we'll take it for a random one, 5.2.5, any leakage. It wouldn't be too surprising if you work through the definition of leakage, which I've not looked at at all, so I have no idea. It wouldn't be too surprising if it covered something that, strictly speaking, wasn't leakage.
Well, my lord, I mean, I accept that they're snappy. I do accept that. So, and that, you know, to the extent that my lord thinks that weakens my point, I accept that. You know, it's a snappy definition. I accept that.
No, the label is a snappy label.
It's a snappy label. Yeah, sorry, your lordship's right. Yeah, the label is snappy. I accept the label is snappy, and in a sense, obviously, if the longer the label, the perhaps the more powerful the label point is. But I accept that. But of course, leakage is a well-known technical term in the context of acquisition agreements, where leakage this is a locked box structure, and leakage is simply a well-known term. So the parties will have known what the leakage is. So it's not quite as that example doesn't really show that these labels don't mean anything.
Can I just go back to your point about for? It's perfectly possible, is it not, to read this definition in conjunction with clause 5.2 as excluding loss arising out of any liability of the target group in respect of ABC laws. Now, that makes perfectly coherent grammatical sense, doesn't it? Liability of target group in respect of ABC laws. What's wrong with that as a matter of English? We will insure you against X's liability in respect of claims by clients. Well, that makes perfect sense.
Yes.
So
Well,
why is or for such an obvious mistake? It all goes back to the correction, to the contradiction.
Well, so your lordship, what your lordship has just put to me would delete the words or actual or alleged non-compliance.
Yes, it would, because the judge interprets this as covering three types of loss. Loss arising out of any liability of the target group, loss arising out of any actual non-compliance, and loss arising out of any alleged non-compliance.
Yes.
And the first of those grammatically makes sense.
Yes. I accept that. I accept it makes sense, and I accept that one could just get rid of actual or alleged non-compliance.
Well, no, you wouldn't, because the alleged non-compliance may or may not result in a liability. In fact, it probably won't.
It may not. That's right. Yes. But it can do.
Yeah.
As one of the points we come to that it can do.
The current point you're making, as I understand it, is on the defendant's construction, the words liability are surplusage.
Yes, exactly. That is the point I'm just about to make. Yes.
Because if you've got non-compliance to give rise to liability, then you've got non-compliance.
Yeah.
And further, it makes a nonsense of the label.
Yes. So at the moment I'm on the first of the points we make in the skeleton, paragraph 38. The first point is the label doesn't correspond to the contents according to my learned friends, and that has two aspects. First aspect, it's not just liability, it's something else. Second aspect, as my lord has just put, if you did exclude any loss arising from actual or alleged non-compliance, you would automatically exclude any loss arising from liability. So the liability actually falls away completely, which is another reason why the literal reading does not look right. Whereas the correction we suggest has the virtue that the whole thing does then become a liability, and the liability becomes what's excluded. In our skeleton at 38.2, we make the point that the other 6 defined liabilities are definitions of liabilities, which we say supports the point that the label is not just chosen at random. At 38.3, we submit that a reader would simply read the first or as for, and really in a way this is a point that just invites the court to stand back and try to form a first impression. It's very difficult after reading arguments and judgments and a day in court, but
I wonder about that.
Yes.
Because surely if you're reading this for the first time, you read that definition and you would read or as or. It's only once you start thinking about the consequences in terms of the interaction with clause 5 and what's in the cover sheet that you start to doubt it.
The reason I don't accept that, my lord, is because it's to do with the order in which you read it. The reasonable policyholder does not simply extract this definition and read it and say, I wonder what this definition means. That's why it's important how one reads the policy. The reasonable policyholder gets to the definition because they've already checked that effectively ABC liability is one of the insured obligations under 13.5 being insured. They've already checked that. Then they've seen it as an exclusion and then they read it. And my submission is that at first read, you see it's a liability. The list of exclusions includes lots of liabilities. You expect it to say liability for, and that's probably how you read it. But this is a point where obviously different minds may differ about what the first impression would be. And it may go to the question, well, is this really a typographical error? But it doesn't really matter. The point, if I'm right overall, then the policyholder who has taken in the whole relevant parts of the policy as they've read it would probably read this as for in my submission.
Well, for my part, I say you go this far, that looking at a definition of ABC liability, and then you read any liability or actual alleged non-compliance. At the very least, that's clumsy.
Yes.
It certainly doesn't. It certainly isn't the sort of clear English that you might expect in this type of policy. And also, it seems to me that if you read it the defendant's way, I don't think it does then say who the liability is of.
Well, as my Lord Justice Lewison was putting to me that the judge, and I'm going to come to the judge in just a moment, expands it into 3 sections. So the judge assumes or finds that it's the liability you then read ... I think it's any liability by any member of the target group. It must be. So that which is not good.
Says any liability in respect to anti-bribery and anti-corruption.
Yes, my lord, your lordship may be right. So in fact, there is a problem there which I hadn't previously spotted. That actually, to make this grammatical in the insurer's sense, it would have to read any liability by any member of the target group, which is not good.
Any liability of.
Well, it should do, yes, but there's no of.
Yes, exactly.
Yes, exactly. So my lord, I'm saying your lordship has showed me that there's actually another problem that I hadn't previously spotted with the judge and my learned friend's reading, which is it can't actually make
The
grammatical
defendant's
sense.
reading is, as I understand it, any liability of or actual alleged non-compliance by.
I see, yes. So they insert an of.
They're asserting an of after liability.
Yes.
As I understand it.
Your lordship may be right, and I hadn't picked that up. But if they're inserting an of, then they're accepting there has to be a correction. And then the question for the court just becomes, well, what's the most apt correction?
I think what it really comes down to is there, do you insert of or do you change your or to for?
Yes.
It must be one or the other to make it read properly.
Yes, exactly. So, my lord, I do adopt that. The final point we make in the skeleton 38.4 is that the simple correction removes the contradiction, and we make the point in B and in footnote 16 that one important form of ABC liability could be a liability under a deferred prosecution agreement, which would be for alleged conduct. And I'll come to what my learned friends say about that in a moment. So we say that for makes much better sense than adding the of and then breaking it up as the judge does. So I'm now going to, if I may, turn to what the judge says about this and then turn to what my learned friends say about it. Now, the judgment on this point, so...
You could have a liability for an alleged non-compliance if there was a settlement with the admission of liability.
Yes, exactly. And a deferred prosecution example is a classic example of that, which is well known to everyone operating in that field. So that's right, exactly.
You don't need anything as sophisticated as a deferred prosecution agreement. You just need a settlement.
Your lordship's right. In civil proceedings, you could just have a civil settlement.
What you're primarily thinking about here in terms of liability.
Yes, and that would give rise to a liability which arose from an alleged breach. Yes, no, that's right, my lord. I accept and adopt that. So going to the judgment, bundle 8 tab 5, the judgment on this point, on ground 2, is he's rather confused, and the reasoning is not defended in my learned friend's skeleton argument. The judge starts his discussion of the textual arguments at paragraph 31, page 48 of the bundle. And conventional starting point is the insuring clause. He then says 2 points emerge. First, the obligation to indemnify was subject to terms and conditions. And secondly, this wording contemplates 2 types of loss to which the policy would respond. 1, direct loss suffered by the claimant insured, and 2, third-party liabilities in respect of which the defendants would pay the third party on the claimant insured's behalf, subject to the qualification in clause 4.1 that what was recoverable was confined to the amount which the insured is entitled to claim. Now, my lords, that second point is not one that was made by either party. As I understand it, it's not one that my learned friends seek to pursue now either. And it involves a complete misunderstanding of the structure of the policy, which unfortunately is central to the reasoning that then follows on this point.
The judge's error here is that he's perhaps lost sight of the fact that the only loss covered is a diminution in value of the shares.
Yes, if I may say so, there's a more specific positive error as well, which is he seems to take the words that he quotes at 31, the words "or pay on the insured's behalf," as indicating that there is this second type of loss covered. I mean, I'm accepting what your lordship puts to me, that he's lost sight of the fact the only thing covered is warranty losses, but he seems to have got a positive idea that there's something else covered because of those words "or pay on the insured's behalf." And as I say, that wasn't something that the parties submitted. And of course, it's, and maybe I don't need to develop this, but it's simply wrong. The types, and we can see back in the policy, the types of loss that are covered. I showed them to you at the start. And there's warranty losses on the first. And then there are things like defence costs and mitigation costs. And of course, those are just the type of thing that an insurer may pay directly. The insurer may pay defence costs on behalf of the insured. The judge's view, though, at paragraph 31 seems to be that there are some warranty claims which would consist of third-party liabilities which the insurers would pay on the claimant's behalf. And that doesn't make any sense. If there is a third-party liability, which happens because of facts which also amount to a breach of warranty, the measure of loss remains the loss of value, as my lord has put to me. The liability doesn't become something that we can claim from the insurers, let alone something the insurers would be paying on our behalf. I mean, it wouldn't even be our liability most of the time. So that he's got that completely wrong. And that then becomes quite relevant to his analysis of the text. And as your lordships know, paragraph 34, he divides the definition, like Roman Gaul, into 3 parts. Any liability in respect of ABC laws, and then any alleged non-compliance by members of the target group, and any actual non-compliance. So his own reading actually doesn't delimit who's liable. It's just any liability.
On the first one, he doesn't insert the word "of."
No, he doesn't. So and as a result, the judge's reading does not delimit whose liability this might be. So this could be anybody's liability.
Well, is that a problem, though? Because as you've just yourself been submitting, the only loss is loss in diminution in value of the shares. So one has to understand this in the context of, we're talking about a loss in the value of the shares. And liabilities in respect of ABC that cause that are excluded.
It would be a very odd idea if it was intended to open up the argument that if there's some breach of warranty which ultimately arose through somebody else's liability for breach of corruption laws, that
to be sure, exactly. So yeah, there has to be a diminution in shares.
there does, for there to be a loss at all, there has to be a warranty claim. I accept that, but my point is that the judge's reading, attempting to just use only the words in the definition, leave you with an attempt to exclude any loss that might arise from anybody's liability for corruption. Now, it may be that in practice it's hard to think of many examples where that would be something else, but it certainly could be, and it would be a very odd thing to intend to exclude in my submission. So I do submit that that is quite strange. And why would you write a clause which defines whose non-compliance counts and deliberately defines it more broadly, but doesn't define whose liability counts?
It's enough for your purposes that the defendants and the judge's construction result in an odd wording.
Yes. It's,
It doesn't have to necessarily go to the extent of saying it's going to lead to huge widening of exclusions. You'd expect a clause defining ABC liability to say whose liability it is.
yes, exactly, my lord. At this point of the argument, we are assuming that there is a problem and we're trying to work out what might be a good solution to it. And I'm saying that the judge's solution is also not particularly coherent. And then at 35, the judge says that we seek to confine the scope of the exclusion to 2 and 3, which is simply wrong. Our correction would confine the exclusion to liabilities in respect of ABC laws, including liabilities for actual or alleged non-compliance. So it certainly includes the whole of 1, and it includes some of 2 and 3. That's our correction. So the judge seems to have misunderstood either what we were saying or what his own construction means, because we're not seeking to exclude 2 and 3. And then at 36, the judge builds on that misunderstanding from paragraph 31, saying that the exclusion clause follows the pattern, with 1 being concerned with direct loss suffered by the claimant, and 2 and 3 with actual or potential third-party liabilities. So he builds on the misunderstanding, and it makes no sense because the loss that's insured is only the resulting loss of value from the breach of warranty. It's not the third-party liability. And then at the end of 36 is another misunderstanding because he suggests that his 1 is concerned with direct loss and his 2 and 3 are third-party liabilities, which really makes no sense at all.
Well, you say that's the same error as you made in paragraph 31.
It seems to be building on it, yes. He's got it all the wrong way around, really. And then at 37, he's misunderstood my submission. And I did go back to the transcript just to check that I did make the submission I meant to make, which I did. He's understood me to have submitted that 2 and 3 would become surplus on the literal construction. But actually that's not the submission I made. The submission I made was that 1, the liability becomes surplus. The same submission as I made to your lordships a few minutes ago becomes redundant. I don't really understand the answer he gives to the point that I didn't make, but it probably doesn't matter. But 4 lines up from the bottom of the page, the judge again relies on this idea that the policy divides types of loss into 2 and says that the warranties refer to conduct that damages the claimant directly or results in third-party liabilities. And that's all wrong. It's true that the breach of warranty might damage the target directly or might result in the target having liabilities to third parties, but it's not correct that those are insured perils. The insured peril is the loss of value resulting from the breach of warranty. So with all respect to an experienced and busy judge, paragraphs 31 to 37, I'm afraid, are just confused about how the policy works. Judgment paragraph 38, by contrast, refers to a point that my learned friends did make and still make. They say it would not make sense to exclude loss from any alleged non-compliance, and that's a point which I think I've now made my submission on. The DPA, or indeed, as my lord points out, simply a civil settlement, both could result in liabilities arising from alleged breaches. But he then goes on to say that the insurer's reading makes sense on the basis of this erroneous idea about third-party liabilities. I think I'm still in paragraph 38. And it's quite clear here that he relies on that because he says an insurer may wish to indemnify or pay a third party in respect of a disputed non-compliance. And that's a clear mistake because there's no basis on which an insurer in this kind of policy is going to go out and indemnify a third party. Then, my lords, what do my learned friends say about ground 2? So I want to look at their skeleton, which I think your lordships have in the supplemental core bundle. 1. And I've covered most of this already, but I draw your attention, if I may, to paragraph 39, where my learned friends confirm that you made the point about DPAs, and they have 4 separate reasons for saying that the point about DPAs doesn't work. First, they say it's esoteric, and I think I've made the submission that I dispute that. It's actually very well known to anybody in the anti-bribery world.
Well, it's actually mentioned in the warranty.
Well, your lordship is ahead of me, and I'm grateful. Of course, in the warranty itself, yes, of course, my lord is right, and it's a point I hadn't thought of, but your lordship is right, it's mentioned in the warranty. So it's not esoteric. Secondly, they say we didn't provide enough law for a safe basis, and that's a non-point because they're represented by very experienced solicitors and counsel and have not come up with anything wrong with what we've said. Thirdly, they say the liability under such an agreement is one that arises from the deal rather than the underlying alleged wrongdoing. But Clause 5 excludes any loss to the extent that it arises out of ABC liability, which is a sufficiently broad causal link to cover a liability under a DPA which arises out of an alleged wrongdoing. And fourthly, they say such an indemnity would contravene the public policy rule that you can't insure against your own criminal liability, which seems to fall into the same error of the judge of thinking that we are seeking to insure our own liabilities, when in fact what we're seeking to insure is a warranty claim if it turns out that the business we've bought has previously committed wrongdoing, so that doesn't work. So, my lords, we say that the small correction we suggest is appropriate for the following key reasons, just to summarise my argument. It cures the contradiction that would otherwise exist, it makes sense of the label, it corresponds exactly to how a reasonable person would read the definition.
Just go a bit more slowly, please.
Sorry, my lord.
Yeah, got the first 2.
Corresponds exactly to how a reasonable person would read the definition in the context of the rest of the policy. And in my submission, it's unique in doing that. Nobody has suggested another correction that would achieve those goals. So it's the right correction. If I'm right about ground 1 but wrong about ground 2, then I say that the other thing the court should do is simply override the exclusion and disapply exclusion 15.
Completely.
Certainly, yes. I mean, it would. Well, certainly insofar as it. I mean, that's what you're left with. If you're left with a contradiction, you have to choose one clause or the other. So yes, you would just say that the exclusion can't be intended to apply. Certainly not to a breach of any of the warranties in 13.5, because that's what it contradicts.
If there's a contradiction, and the contradiction can't be cured by a corrective interpretation, we simply disapply the exclusion.
Yes. At least insofar as it is said to apply to 13.5, because that's what it contradicts. There are other warranties where we don't allege a direct contradiction. But in terms of 13.5, we say it directly contradicts all of those. And we invited the judge on this to follow FCA and Arch, the Supreme Court, where they did exactly that. Now, I accept that, of course, that was a much longer piece of wording. The contradiction in some ways was more obviously impossible to resolve. But nevertheless, at the end of the day, they said, well, a reasonable person would not find this would not find the exclusion, and the answer is just to not apply it. And we invited the judge to follow that. The judge did not deal with that in his judgment. Now, I accept it's a last resort. Your lordship, I think, looks slightly sceptical about it. And I accept it's a last resort because it's much better, if we can, to correct the definition to give the intended effect. But if I'm wrong about that, then the relevant principle is you have to ask, well, what's the fundamental purpose of this policy? It's to provide the cover that is defined. And if there is another clause that contradicts that purpose, you can't resolve the contradiction. It's treated as ineffective. As I say, the judge doesn't deal with this. My learned friends do. So the last thing I want to do on my appeal is just to refer to what they say about this. So again, my learned friends skeleton in that supplemental bundle, page 18, paragraph 40. They say the judge did consider the argument. They refer to paragraph 37 of the judgment, and that's wrong. I mean, the judge does refer to the test case, but he doesn't refer to this argument. I'll let my learned friend show you if he really wants to say that he did. 42 and 43, my learned friends say that the situation in the test case was different, and I accept that. I'm not relying on that case as an analogy to the particular wording. I'm just relying on it for the principle that an exclusion is what has to give way at the end of the day if no other tools are available. At 44, my learned friends say that it's important that brokers and solicitors were involved in the negotiation. And in my submission, that doesn't really address the issue, because at this stage of the argument, we've reached the position that all of the advisors have missed the fact that there's a contradiction, it doesn't quite work. And so the position becomes, well, if it can't be corrected, which one gives way? And the fact that both parties had advisors doesn't actually assist on that. So, my lords, that was all I wanted to say on ground 3. I could make a very brief submission on the respondent's notice. Since it arises, if I'm right, it probably makes sense for me to make a brief submission, unless your lordship prefer to. Yeah. So, the insurers say, if you decide the appeal in my favour, then you should address issue 3, which the judge did not decide. We can see the sense in that. We do say that technically there should have been a respondent's notice with a contingent cross appeal, but we've got no objection if your lordships are willing to hear it. Issue 3 was whether...
So there was a respondent's notice, and your point, I think, is it should have been a cross appeal.
Yes, right. Yes, my lord is right. I'm sorry, I've forgotten that there was a respondent's notice, but there's no cross appeal. Yes, it should have been put as.
And
They needed
the only
permission.
reason why that would matter is because a cross appeal requires permission,
Yes, exactly.
whereas a respondent's notice doesn't.
Yes, exactly, my lord. So they need. In my submission,
Is it your submission they shouldn't have permission?
it's not. No. We made it clear in correspondence. We've no objection to them having permission, but we say they should have asked for it, and they haven't. So I just draw it to the court's attention that there should be permission. We have no objection to it being granted. Issue 3 was whether exclusion 15, as construed by the court, excludes any or all of the breaches of warranty. Now, there is a small error in that formulation because it should ask whether the exclusion excludes loss arising from the alleged breaches of warranty. We say that's just an obvious correction to the way we formulated the issue. If your lordships would look at the amended particulars of claim, at bundle A, page 68, which is in tab 8, you will see, starting at the foot of the page, the breaches of warranty that we allege. We refer at the foot of the page to the fact that some matters are confidential, but then we set out on the next page and going on, the key paragraph is really 36. I'm just giving you the rest of it really to show you the context. But 36 is our claim that as a result of those breaches, we have suffered loss and damage. Shares had a lower value than would have had if the warranties had been true, and in particular, we then set out why we say what we paid was the warranty true value, and the warranty false value would have been less, and we set that out in some detail on a couple of hypotheses. And we say that the loss we claim is one that arises from the target's alleged or actual breach of ABC laws, but not from any liability for such breach. So that's what we're saying, that loss of value from their alleged or actual breach of laws, but not from any liability that they have as a result. Now, we say, therefore, that we're on the right side of the distinction drawn by the exclusion as it should be construed, and that that's the answer to issue 3, that the exclusion does not exclude the claims we are making for the losses we are alleging. So we therefore invite you to find issue 3 in our favour, that the losses from the breach of the warranty that we claim are not excluded. My lord, I'm not proposing, since it is a respondent's notice point, having introduced it in that way, I propose to answer any points my lady friend makes on it later. I mean, you've seen what he says in the skeleton, and we put in a supplemental skeleton answer. I think you need to, unless your lordships want to hear me on that, I would propose you to say more about
Yes, I find it difficult to see what meaningful answer we can give to issue 3, frankly, without a factual investigation. But
Well, that is one of the points made against me, which I dispute, my lord, because all the issue is whether the breaches we allege fall within the exclusion, and the breaches we allege are nothing to do not arise from liabilities. They arise from actual or alleged breaches of the ABC laws and regulations, but they do not arise from liabilities. We don't allege anywhere in paragraph 36 that any amount of liability is what's caused our loss of value. And so that's the point which we invited the judge, and he obviously made the order that there should be these preliminary issues, which we invited him to decide. And my learned friends say you should decide it if you allow the appeal, and I accept that, because it is actually a point simply of looking at the paragraph of the pleading, particularly paragraph 36 in my submission. So that's what I say about it, and how I say you can decide it in my favour. My learned friend says we haven't proved that the breaches are true, but we don't need to do that, my lord. That's not what the issue is about, as we've set out in more detail in our supplemental skeleton. My lord, subject to your lordship, so those are my submissions.
thank you, Mr. Southington. Yes, Mr. Quiney.
Good afternoon, my lords. Just sort out my bundles if I may. My lords, I propose to deal with 6 issues, if I may. The first is to review the high hurdle the appellant must face and get over when dealing with an argument based on construction by correction, and that's whether one's looking at the clause and whether it's inherent nonsense in itself, or looking at it, which is the crux of the appellant's case, as the contradiction between the exclusion and the spreadsheet as it's described. So just understanding how high that hurdle is for this particular appeal. The second is then to look at the characteristics of a policy of this type, and particularly this policy, before then third coming on to the question of the words actually used and a review of the policy as a whole, including the key clauses my lords have already been taken to. And then consider the relationship between those parts of the contract. And then fifth, come to the question of the reliance on the FCA case. And then sixth, I'll address you on the respondent's notice point. So what we have here, as my lords will know, is an appellant who acquired a construction company that had entered into an SPA and then sought cover after the SPA had been agreed.
Sorry to interrupt you so quite so soon. On your list of topics, does one of them include the question, what, if any, breaches of warranty 13 are covered by the policy?
We will deal with that when we look at the terms of that.
Right.
And I'll hasten to add, before I move on to the detail, I'll be looking at the 3 points my Lord Justice Lewison and yourself brought up as perhaps a logical and coherent way of approaching these issues. So we have the SPA having been agreed and then the cover being sought, and within the process of negotiations, the ABC exclusion being included. And so the real trouble here is not that the ABC exclusion in and of itself doesn't work. There is no allegation that this is nonsense, for example, to borrow a word. It simply doesn't work the way we say the appellant wants it to work. And it is accepted that the primary case put forward by the appellant is not, for want of a better phrase, to junk the exclusion. That's the last gasp. That's ground 3. The point here is how we can make, and I suggest this as a starting point, the policy work harmoniously. And we say that it can do, and insofar as any doubt, the Policy Act explains how to do that. Equally, when one looks at the case law on these issues, I suggest that there are 2 things. The first is to look at the high hurdle. And the second is to understand how policies of insurance can sometimes be constructed. And on that point, we'll look at, for example, exclusions aren't used in a narrow way that my own friend suggests, but are often used to delimit the extent of cover as well as exclude claims. So dealing with that point first as to how to generally approach, it'll be familiar territory to my lords, but if I had to adopt something, I would suggest that the judge's analysis of the law and summary of the principles is a good place to start, and that is in the judgment in Bundle A, tab 5. Starting at paragraph 15 of page 41.
Yeah. Don't think anybody's quarrelled with anything the judge says in paragraph 15.
And the reason I go to that is because I don't believe any of the parties would quarrel with that. And so it's a safe ground between the parties, certainly, and I'd suggest for this court to start. And so with that in mind, one has to consider what the high hurdle is. And I suggest that one comes to Chartbrook as perhaps even not just the start, perhaps actually even the end of this, but we will look at a couple of other cases, if I may, after that. So Chartbrook is in tab 1 of the authorities bundle, so the first bundle for my lord, I believe. If I can take my lords to Lord Hoffman's speech, starting at page 12 of the bundle, para 14 of the report, which is obviously something my lords have been taken to already. What I'll be doing, if it may take a few minutes, is go from paragraph, or look at the points of paragraphs 14 through to 25, which again will be familiar territory. So at 14, we have the general articulation of principle, and we can see it 4 lines down. Lord Hoffman says it is agreed that the question is what a reasonable person having all the background knowledge which would have been available to the parties would have understood them to be using the language in the contract to mean. Now, the reason why I mention that familiar passage is, of course, that is the task that we have here. Is there a real contradiction, even if there is some concern as to the use of language? To borrow my Lord Justice Phillips' point, it might be odd language, but it doesn't mean it can't tell us what the parties intended here. And bearing in mind how the genesis of this policy and the fact that this was a bespoke policy, to use the words of the judge, heavily negotiated with expert advisors on both sides, for example, for the claimant, for the appellant, their broker and their lawyers, and given that the SPA and the disclosure letter and the access to the VDR, the virtual data room, are all available within that process. And that's why, as Lord Hoffman goes on, he says, but said in some cases, the context and background drove a court to conclude that something must have gone wrong with the language. So you already see the rare nature of arguments of the type that the appellant seeks to run here. And at 15, it clearly requires a strong case to persuade the court that something must have gone wrong, that the language and the judge and the majority of the Court of Appeal did not think that such a case had been made out. So yes, one might disagree about particular ways in which a clause is drafted. One might want greater clarity, particularly with the benefit of hindsight, but that's not enough. And then he goes on, Lord Hoffman goes on halfway down paragraph 15, such a division of opinion occurred in investors' compensation scheme. The subtleties of language are such that no judicial guidance or statements of principle can prevent it from sometimes happening. It is fortunately rare because most draftsmen of formal documents think about what they are saying and the use of language with care. But this appears to be an exceptional case where the drafting was careless and no one noticed. Well, this present case is not such an exceptional case, we say. Then going on to para 17 and the point regarding labels and the points that my learned friend relies upon on that. And towards the end, halfway through rather, he identifies the nature of the symbols or labels used in the persimmons contract and makes the point, and I say the right point, it uses labels. Words used as labels are seldom arbitrary. They are usually chosen as a distillation of meaning or purpose of the concept intended to be more precisely stated in the definition. Well, that can be said about all of these parts of this contract, and particularly the definition itself. Now, to borrow my Lord Justice Arnold's point, the way that the exclusions are phrased is snappy. The way that they are put is a shorthand. But it's the definitions where the care has been taken and where one can divine the intentions of the parties. And even if they might be described, to use my Justice Phillips' points, as odd, it doesn't mean we can't tell what they meant. And as we'll see when we look at the chronology, for example, or look at the policy, it is clear. But what is it in Sharpbrook that struck their lordships, Lord Hoffman in particular, as out of the ordinary, something going wrong? And we have a flavour of that at para 19, where he says, "My lords, I cannot believe that any rational parties who wish to make provision for such a catastrophic flaw in the housing market would have adopted so precise a sum to represent their estimate of what happened. Why £53,438? That was agreed minimum figure for that part of the value of the flat attributable to the land which Sharpbrook was selling." And then he describes this is some sort of guess as an extraordinary fall in the market. And he describes this could only be wild speculation. And then at para 20, he says, "It is of course true the fact that the contract may appear to be unduly favourable to one party is not a sufficient reason for the supposing that it does not mean what they says." And that's true here. But he concludes at the end of para 20, "It is that they make the structure and language of the various provisions of Schedule 6 appear arbitrary and irrational when it is possible that the concepts employed by the parties to be combined in a rational way." So it's so irrational, so out of the ordinary, and yet also he can see the solution, the two elements of the test, as we will see here. And that is far removed from the points being made by my learned friend in this case. And if we could go over the page at para 22, we see how we apply the test. So here he quotes from Easton Pantellis. Lord Justice Brightman stated the conditions for what he called correction of mistakes by construction. Two conditions must be satisfied. First, there must be a clear mistake on the face of the instrument, and secondly, it must be clear what correction ought to be made in order to cure the mistake. If those conditions are satisfied, then the correction is made as a matter of construction. And there are two qualifications at 23 and 24 I'll mention in a minute. But what the oddity of the case here, of course, is it's accepted that on the face of the clause itself, there is a sensible clause that has effect, because we all agree what the effect of it is.
Well, I'm not sure that's true. What Lord Justice Brightman says is that there must be a clear mistake on the face of the instrument, not in the particular clause. And I don't think it is accepted that there isn't a clear mistake on the face of the instrument, that is to say, the policy.
Yeah.
Even if, in isolation, the definition can be given some meaning.
And my lord, you'll see the second qualification of para 24 that I was going to come on to is exactly that point.
Well, that's a slightly different point. That's saying that you can look at background and context. I think Lord Justice Brightman was talking about the instrument, not the particular bit of the instrument.
And my lord, if the point is one has to look at the coherence of the document as a whole, I would agree. But one has to start, I would suggest, with the clause in the first place before one can even test coherence. And my point is perhaps a shorter point, which is there's no dispute that the clause
Yeah.
works. The problem is whether it works
In the
within
context,
the body
yes.
of the body of the whole agreement. And then the next question is, what is the cure? And that is, again, a point raised in submissions earlier. Does it have to be a change to this clause, which otherwise works? Or is it a change to other parts of the policy? And I'll be saying that you don't need to make a change, it does work, and I'll come to the 3 points that my Lord Justice Lewison identified as the logical structure in a minute. But the two qualifications here is that, of course, correction by mistakes or constructions, the first one, is not some sort of separate part of the law. It is all part about elucidating the intention of the parties. And so I would say, is it clear from the body of the document that the one thing that the parties agreed the insurers would not have to touch, and certainly on our interpretation, are losses arising from bribery and corruption as defined as an ABC liability. If there's one message one takes away from the way the exclusions are put together and the way that the definitions are put, if there is a loss, a reduction of value in the company caused by bribery and corruption, is that something the parties have agreed insurers should indemnify? Now, we'll talk about the details in a minute, but if one asks that big picture question, the answer is clearly no. The insurers
Well,
did not.
only if you put the spreadsheet out of your mind.
I'll be explaining, if I may, shortly, my lord, that you don't have to put the spreadsheet out of your mind to do that. And in short, the spreadsheet, we say, isn't a contradiction in itself because, first, it is there simply to summarise what's the scope of cover, i.e. what is, as a matter of principle, within the policy. What it's never saying, and that's clear from clause 3.1, i.e. subject to all the terms and conditions, or subject to the rubric, as my learned friend describes it. What it isn't saying is that's the end of the matter. That's simply the beginning of the question.
It does say it's conclusive.
Precisely. And so if it's not conclusive, it's just telling you what's in the policy.
There's a cover sheet says it's conclusive.
Sorry. What I'm
Well,
saying
that's
is
what
it's
it-
not conclusive on the question of what will pay out under the policy.
No.
It's simply conclusive on what is within the scope of cover of the policy, subject to the terms and conditions, including the exclusions.
What you're saying is that when you look at the exclusion of ABC liability, it's clear from that that these insurers are not providing any cover for bribery and corruption losses.
I think I'm making 2 points. The first is a particular point, which they're not going to indemnify for loss arising from it.
That's cover.
Well, no, the cover exists within the terms and conditions of the policy. So it might be right to say these particular warranties are within the cover. But if the loss that is claimed as a result of those warranties being breached arises from something that's identifiable as ABC, then that isn't something that the insurer has to pay out on. So, my lord, you're right, in the broader sense, it is about what's covered and what isn't covered. But what I'm focusing is on the way that the policy is structured. You can say something's within cover, but because of the operation of the exclusions, it might be a leakage question, it might be a tax deferral question, it might be a fraudulent question, as we'll see when we look at the policy terms. That then says, well, that would have been in cover, but because it's caused by, in this case, ABC liability, it is now outside of cover. We're not paying it. So that was the more detailed answer to your question, but I was making a more broader point in the context of the general guidance from Sharpbrook and other cases, which is if you're asking the reasonable policyholder what is agreed here, and this is sort of colloquial or broad sense, is it the case that the parties are agreed that the insurers are not going to be on the hook, so to speak, for ABC liability. Is that the message your one gets from this?
But this, forgive me, this identifies the very crux of the issue, isn't it? Which is that one quite understand that in many policies there will be insured risks, and then an exclusion will say, well, we won't cover losses in relation to that insured risk because it arises from terrorism or whatever.
Yeah.
And maybe bribery and corruption.
Yeah.
Quite understand that. But if it's excluding any liability for losses arising out of bribery and corruption, you would not then expect to see under the express provisions relating to the scope of cover for bribery and corruption. Just as like you would, it's like if you had an exclusion of terrorism, but then the cover showed that it was covering you for losses from terrorism.
Well,
That would be a contradiction.
yes, and that's where I part company with you, my lord. I understand the proposition,
Yes.
and certainly, for example, the textbook cited by my learned friend, the extract from Clark, makes the example similar to that. I accept that as a proposition. My point here is that that is not a proposition that is applicable to this case. And I say that for a number of reasons. Now to adopt, if I may, my Lord Justice Lewison's test, which is there a contradiction? If so, does the policy tell you how to solve it? And if it doesn't, how do we solve it nonetheless? What we're focusing on is currently the first part of that proposition, which is there a contradiction at all? I say that there isn't a contradiction at all. A, because of the nature of what the Appendix C is doing. It is simply defining the scope of cover by reference to the warranties. And for example, the warranties aren't expressed exactly in a mirror image to the exclusion. For example, there are
Well, I think you will need to show us what, if any, claims for breach of those warranties could fall within cover and outside the exclusion, i.e. for which insurers will pay up.
I will endeavour to try and explain that
Yeah.
point when we come on to it. I was just seeking to deal with my Lord
No, I
Justice
follow.
Phillips' points, if I may. In summary, and the second point is, of course, looking at the actual text of Schedule Appendix C, we see on the face of it, it expressly says subject to exclusions. And that's the second point in my Lord Justice Lewison's analysis.
I don't think it does say subject to exclusion.
Well, my lord, if I may just take you to the policy.
I think it says notwithstanding certain things may be covered, certain losses may be excluded.
Yeah.
And then there's a debate about what that actually means.
But that's completely anodyne, isn't it? And doesn't resolve the issue that we are dealing with.
Well, my lord, if I may take you to Bundle B, page 213.
Yeah.
The short point is, I don't accept that it's entirely anodyne. So you have the cover spreadsheet explain what they are, and then you have this before you get into the body of the spreadsheet. It says, notwithstanding that a particular insured group obligations marked as covered or partially covered, so pausing there. The word notwithstanding is abundantly clear that this is a matter of primacy and is paramount importance. And then expressly discusses the particular contradiction that my learned friend seeks to place weight on, which is, even if it says it's covered, does it mean it's covered? And the solution is, certain loss arising from breach of such insured obligation may be excluded from the cover pursuant to Clause 5 of the exclusions. So the very conundrum that my learned friend seeks to rely on is, just because it says it's covered, can it still be excluded? Is expressly addressed by this, because it says when something is covered, then certain loss arising from that breach may still be excluded because of Clause 5.
So this is what I described as stage 2, is it?
Yes.
You say if there's a contradiction, the policy tells you how to resolve it.
We are given the tools to resolve that. So utilising my lord's structure and dealing with my lord Lord Justice Phillips' questions. The first point, which I will seek to make good after lunch, is that there is no contradiction because of the way that the policy is designed, i.e. it can work harmoniously. If you're not convinced by that, the answer is here, which is telling the reader and the reasonable policyholder that just because, and paraphrasing it obviously, just because it says covered doesn't mean it's not subject to the exclusions. Look at the exclusions. And then the third point is, even if you're not with me on that, looking at the way in which this cover spreadsheet interacts with the inclusion of the exclusion on ABC liability during the negotiations, it isn't a school draw, to use my learned friend's phrase. It is clear that the ABC liability should be paramount because it's a special term. And I'll take you to Mr. Justice Felston's judgment on how one might resolve these sort of conundrums at the third stage.
Yeah.
So, my lord,
Would that be a convenient moment?
would be a convenient moment.
Thank you very much. 2 o'clock.
All right.